Why don't we get started? I wanted to thank you all for coming to this. Is the third of 4 faculty book celebrations this year. And we're here to celebrate Cynthia Bowman's book, Unmarried Couples, Law and Public Policy, published by Oxford University Press, in stock at Amazon. Cynthia Bowman doesn't need an introduction, but for those of you visiting from outside the law school, she joined our faculty in 2007 as the Dorothea Clarke Professor of Feminist Jurisprudence. She's a graduate of Swarthmore. She has a PhD in political science from Columbia, her JD from Northwestern, and is published widely. In fact, so widely we could have had 2 book celebrations for Cynthia this year. We had to make her choose because incredibly, really in the same month that this book came out with Oxford, she also published a second book, a biography of Dawn Clark Netsch, published by Northwestern University Press, and I believe that's also available on Amazon. So check that out. We have, an incredibly distinguished panel today to talk about Cynthia's book, and I'll introduce them all at once, and then they'll speak for about 15 minutes each, and I'll introduce them in the order that they're going to speak. Presenting first will be Sylvia A, who's the Elizabeth K. Dollard Professor of Law, Medicine, and Psychiatry at NYU Law School. She's also the co-director of the Arthur Garfield Hayes Civil Liberties Program. She has her JD from NYU and did her undergraduate work at Antioch, is the author of numerous books and articles in health law, family law, and feminist legal theory. Speaking second will be Martha Field, who's the Langdell Professor of Law at Harvard Law School. She did her undergraduate work at Radcliffe in Chinese history and got her JD from the University of Chicago, and has also written and published numerous books and articles in the field of family law and disabilities law and the law of reproductive technology. And then finally, we have presenting Sharon Sassler, who is an associate professor in Cornell's Department of Policy Analysis and Management. She did her undergraduate work at Brandeis and received her PhD in sociology and demography from Brown. Her research examines factors shaping the activities of young adults and their life transitions into school, work, relationships, and parenthood, and has written repeatedly about the topic of Cynthia's book, the phenomenon of unmarried cohabitation. So with that, I'll turn it over to Sylvia.
Thank you very much. It's a delight to be here. It's a delight to celebrate my friend Cynthia and her wonderful book. This book is a brilliant exploration of a very important topic. It is so deep and so nuanced that I struggled to find anything that I could say that was the least bit critical. And I've come up with some ideas. But first let me just say a couple words about the book. It details the dramatic growth in the number of families formed by cohabiting heterosexual couples in the United States today. It demonstrates how the law fails to protect these families, and particularly fails to protect the more vulnerable members of those families. And it proposes sensible reforms to impose marriage-like default rules with the freedom to opt out for people who really don't want to assume marriage-like obligations to one another. If the book did nothing else, it would make a powerful case for the reform that it proposes. But in addition, the book examines how cohabiting relations function along a variety of dimensions. It's informed by richer sources of data than were available to anyone 20 years ago, and a wealth of scholarship that analyzes that data. But most important, Professor Bowman's analysis of how cohabitation works in practice pays close attention to the critical details of class, race, age, and age cohort. Bowman concludes that overall, cohabiting families do about as well, or maybe on some dimensions a little bit worse, than families grounded in marriage. The other factors, class, race, age cohort, are far more important than the differences between cohabitation and marriage. I love the fine-grained identification of differences amongst all these dimensions. For example, differences among various types of Hispanics. It's not enough to just say Hispanic. You have to ask, is it Puerto Rican or is it Mexican? In its attention to detail, the book is, I think, a model. It's very difficult to say anything about families or about family law without attention to these details, particularly about race and class. And very little scholarship is characterized by that kind of attention. So I want then to identify 3 issues on which I wish Cynthia had said more. Perhaps they're the beginning of the next book, or at least the next article. And that's the best kind of scholarship, where you're happy to have read it, but you're waiting for the next installment. First, I wish that the book had said more about the impact of cohabitation on children. That seems to me a critical issue. It notes that 40% of cohabiting households include children, and that 6% of American kids live in such households. Cohabitation produces economic benefits for kids, at least relative to single-parent households. Nonetheless, cohabiting relationships are less stable than married relationships, and instability has a negative impact on children. It offers some anecdotal evidence that children from cohabiting homes are somewhat less successful on a variety of dimensions than children living with their biological married parents. But the discussion of that brief discussion of children made me want more. I assume that this is attributable to limits on the available data. But information about those children in cohabiting homes is important. It illuminates our general attitudes towards cohabitation, and it also may inform the way we think about the consequences that would flow if Bowman's proposals for reform were adopted. For example, when cohabitation ends, should cohabiting parents have the right to visit with and maintain relationships with their non-biological children? Bowman's proposal directs us to look to the law of marriage, and more specifically to the law of step-parents. And traditionally, step-parents had no right to maintain relationships with their former stepchildren. And that was often a really bad result. More recently, some states have recognized that in some situations, the assumption that it's not in a child or a parent's best interest to maintain a step-parent-child relationship can be challenged. Well, should the rule with respect to cohabitants simply follow the messy rules that we now have with respect to marriage? Perhaps. But that would certainly be the simplest thing to do. But without knowing more, I think, about the texture of the variety of relationships between cohabiting step-parents and their children, it's hard to know how to think about that problem. As another example in relationship to children, as a formal matter, step-parents are not legally obligated to support their children in most states. Nonetheless, they often do so and are often expected to do so. For example, loan applications for higher education routinely demand financial information about step-parents as well as parents, even though the step-parents are not legally obligated to support. Whether or not this inconsistency is wise it's an interesting question whether the policies applicable to married step-parents should be extended to cohabiting de facto step-parents. So a second point, so my first point is I'd like to see more on kids. My second point, on which I'd love to hear more, is whether and how these richly detailed experiences with heterosexual cohabitation illuminate the current struggles in relationship to same-sex families. As an author, I think Bowman was very wise to focus this book on heterosexual cohabitants. My sense is that same-sex couples have been much more studied and certainly much more theorized than heterosexual couples. And it's great for straight couples to now have a book of their own. But now that they've got it, it would be good to explore the similarities and the differences between gay and straight cohabitation. Finally, Bowman's primary focus is to demonstrate in elaborate detail that heterosexual cohabitants are pretty much as functional or as dysfunctional as married couples. But she never squarely argues that people have an interest, a liberty or a privacy or a self-expression interest, an important interest in making choices about these intimate relationships. Who you live with is obvious, at least to me, a core liberty interest. Married people have always had the right to pick who they're going to marry. And we all know people who get married and we say, what is she thinking? They're making a big mistake. But apart from barring sub-teens from getting married and prohibiting bigamy and same-sex marriage, we let people marry whoever they want to. People are not even required to know what it means to get married. You need to study up and pass a test to get a driver's license. But marriage, you don't even have to watch a video to learn what you're getting into. Prisoners who are deprived of virtually every liberty are constitutionally and legally protected in their right to get married. So we've got a lot of respect and protection for marriage. I would love to have seen an argument that that kind of protection should be extended to cohabiting people as well. Bowman notes that as recently as the 1970s, people were routinely punished, fired from public jobs, denied public housing, kicked out of school because they cohabited. When I joined the bar in New York in 1968, the Committee on Character and Fitness devoted enormous effort to ferreting out evidence of cohabitation on the part of would-be lawyers. It was part of the character process. The last Supreme Court statement on the status of the liberty interest of cohabitants was, I think, a case called Hohenbaugh v. Carnegie Free Library in 1978. In that case, 2 employees of the public library were fired because they lived together and raised a child. The lower federal courts upheld the firing, and the Supreme Court denied review over a vigorous dissent. As Bowman demonstrates, the practice has changed dramatically, but that case has never been overruled. It's never been noted as wrong in the lower federal courts. I think that Bowman makes a powerful argument from the facts that we should support and respect and nurture cohabiting relationships, but I think there's also an argument to be made from the principle. Thank you.
Good afternoon. I'm Martha Field. I'm very honored to be at this beautiful law school and talking about such a wonderful book. I think before I start, I'll react to Sylvia's first 3 points. First of all, I'm glad that Cynthia left out children, largely because I think it would lead to a very different emphasis in this book. That is, I think we'd get off on that. Indeed, I think that the emphasis that she has chosen is one of fairness between parents. So there is something about how stability affects children and so forth too. So while I would look forward to a book that would talk about the relationships of unmarried couples to children and how that ought to be done, I think another book would be perfect for that. Secondly, I don't think either heterosexual cohabitors or LGBT cohabitors need a book of their own. I think that we should be able to come up with a set of rules, like the rules perhaps that Cynthia has come up with, that are the same for LGBT and unmarried heterosexual couples. I do understand why Cynthia doesn't take this on. I think she's smart not to take it on. I think she says at the beginning, too, that implies that the same rules could apply to both, but that it's simply too hard right now to try to push it's hard enough to try to push it for heterosexual couples, but the political issues around gay rights really would make that just too big a project. Although someday, perhaps, a book that combines them both, and I think would have the same rules for both. And on Sylvia's third point, disappointment that there isn't more emphasis on the liberty interest in making choices. I think that, I'm not sure if Cynthia agrees, but I don't think Cynthia really believes in this ability to make free choices, as my later comments will suggest. So that does it for Sylvia. Now let's get around to Cynthia. This is a wonderful book. It makes you wonder why it wasn't written before. Indeed, ever since Eisenstadt v. Baird, which the Supreme Court decided in the mid-1970s, that case said that single people had the same rights to birth control and the same rights to have children that married folks had. So it seemed from that, I mean, many of us thought from that there would be a constitutional right to sex outside of marriage. It seems to follow. But it wasn't until a few years ago in Lawrence versus Texas that the Supreme Court actually so held, and claimed until then that it hadn't passed upon the legality of fornication, adultery laws, and of sex outside of marriage. In Lawrence versus Texas, however, they said adults were entitled to privacy in their sex lives. So in between, there was really a lot of mystery about what the status of unmarried couples was. There were some state protections against discrimination, making people rent to unmarried couples and that kind of thing. But for most purposes, this subject was largely out of view. Cynthia Bowman's book fills this long-standing void. Her thorough research has given us a great deal of information about state law developments that took place prior to Lawrence. She also has let us know that cohabitation is very much a growing phenomenon. She tells us about the many varied folks who do cohabit rather than marry, and she gives us some idea of why. She tells us about other countries' experiences with cohabitation and their rules about it, putting our system in a revealing context. This research about what is actually happening is invaluable. Most impressive and most memorable of all are the stories of the vulnerable parties, most often women, who have been hurt by trusting in their partners and in relationships that have not lasted. Of course, that happens in marriage as well. But the laws about marriage, property distribution, Social Security benefits, tax-free inheritance, for example, offer some safety net of protection when a marriage ends. Persons who've cohabited for a long time or even raised a family together lack meaningful protections in most of this country. Cynthia makes a very convincing case that they deserve protection and that extending protection to them will not harm the institution of marriage. Cynthia has a solution, and after all this praise, I know I wouldn't sound like a law professor unless I came up with some criticism, so I think what I'm going to do is criticize her solution. Not that I have a better one. So I also applaud her solution because it really got me thinking, and there's a lot of parts of it that I like. So what Cynthia's going to do about this is say that after 2 years of cohabitation, or earlier, if the cohabitation has resulted in the birth of a child, the incidents of marriage will attach to the couple. All incidents. Now, all incidents, I was wondering what those were, because most of what we think of are the financial incidents, and most of the examples she gives show the shortcoming of not having financial protections for when there's death or dissolution, property distribution, or inheritance rules. But also, she says all incidents, and I think the reason is that she wants to include other government benefits, like Social Security, survivors' benefits, or also wants to include things that are available to family members, usually ability to have hospital visits, ability to sue for loss of consortium, and so forth. Now, it feels odd to talk about these as all the incidents of marriage, because it certainly is a very different list than would have been given in the 19th century, or that the church would give today. I mean, we don't usually think of it just as benefits, right? Just as money and money-like things. And indeed, one might ask whether you do talk about the benefits as well as the responsibilities, but one benefit I wondered if whether it would stretch to that is being taxed as married couples. That is, whether you'd have to be taxed as a married couple. Of course, that's beneficial to many people to be taxed as a married couple, but it also, depending on their individual levels of income, can be detrimental. So one thing cohabitors do now is choose between these, and I think maybe that would go. Okay, so people can all the instances of marriage will attach. However, Cynthia says, and this is her respecting freedom of choice, people can opt out prior to the 2-year deadline. And if people opt out, they can, you even at one point suggest that there be some simple form that you can sign and say, no, we don't want to be bound by the instance of marriage. We'll keep our separate existence. Thank you very much. And then she finally says, which I find almost the most amazing, if they're unwilling, although maybe it follows naturally, if they're unwilling to do either, to either take on the instance of marriage or to opt out, they have to cease to cohabit. I was surprised by that. Okay, so here's my problems. First problem is with the idea of marriage by default. Being essentially a passive person, I looked back on this and wondered how many times I've been married. But anyway, others of you may have some of the same problem. But the idea of sort of slipping into marriage unaware or without choosing that seems a lot. Last weekend I moderated a gay rights conference, and one thing that came up was gay marriage. And there was at least one person on the panel who was extremely critical of gay marriage. He said it wasn't a plus, that now his parents kept asking when he was going to marry and have children, which he thought he'd escaped by his choice of lifestyle. And basically he was saying marriage shouldn't be privileged. It shouldn't be the model for society. It shouldn't be set forth as the ultimate good. Instead, you should allow singles, real singles, and you should allow liaison of all types. And actually, one thing that the cohabiting thing doesn't work for is, when there's 3 or 4 people or something like that who want to get together and have a family relationship. So one problem is people who, in some sense, have chosen not to be married are in some sense going to end up being married. A different point. And I guess this would say that, well, you're not forced because you can opt out. But I have some problems with the opt-out idea. I am sympathetic with the choice not to require registration because, as Cynthia says, it wouldn't work to have registration of unmarried cohabiting couples because many of the most vulnerable people wouldn't know they were supposed to register or wouldn't register. So, but the problem is that without registration, how do you measure the 2 years? How do you know when the 2 years starts? I mean, you may say, well, you know when you're cohabiting, but you know, these things can happen gradually, 1 night a week, 3 nights a week. So how do you know when it starts? Indeed, how do you know what it is to cohabit? I was extremely surprised by Cynthia's example of singles sharing a room at college. And she seemed to think that they had to break up after 2 years, too, sharing a room, sharing an apartment. Now, I think she's assuming that they do have a sexual relationship, but I think sometimes people will be living together without a sexual relationship or without cohabiting regularly. And so I think there's some ambiguity about who is cohabiting, who falls within this, and what the definition is and when it starts. I do think that making them break up after 2 years is quite intrusive. I mean, I suppose there's no other way to give people the choice between taking on all the incidents of marriage or opting out. But it's a little intrusive to say you can't live together any longer because we think you're cohabiting and you don't want to do any of these things that we want. And I think sort of deep down, and this is why I'm going to come out saying that I don't really think that Cynthia believes in free choice, at least not as much as she believes in protection of the vulnerable. You seem to value stability very much. When you're talking, often when you're talking about adding in the incidents of marriage, you're saying that can really help stability. You reinforce marriage as the ultimate social ideal, and I'm not sure that you want to do that or that you should want to do that. That is, not everybody wants a stable, long-term relationship. You say at one point that both parents and children are better off in a long-term marriage or a long-term relationship. You're very pro-stability, but I think not everybody would agree with that, and certainly not everybody who's chosen to cohabit rather than be married. So my next problem with her solution is who takes care of the 2-year deadline? Not only do we not know when cohabitation starts, but after 2 years, the incidents of marriage are going to be presumed to apply to them. And I don't even know if they will know when that 2 years is up or if anybody will be keeping count of that. That's why registry would make a difference, because it would be 2 years after registering. But we found we can't really have a registry. So I don't really know. Well, one thing that Cynthia suggests, I think rather brilliantly, is that, we should have a lot of TV shows that show people getting married by mistake, by waiting too long, and then the popular culture would pick this up. But particularly if you don't know when the 2-year line is, I think there is a danger of people slipping into marriage or not knowing when they're when this new status has come upon them. You do recognize that it takes that you have to rely on people knowing about this, but at the same time you say elsewhere in the book that people know very little about their married status. There's all these people who think they're married and they're not, or think they're common law married, or think they're protected anyway. And in fact, you convinced me there that people don't always know what's going on, and so I don't really know how they're going to get it together to make this two-year choice. Still a bigger problem with opt-out, I think, is that maybe you still should require fairness. And I actually think your various positions are in some tension with each other. I think if you allow an opt-out, and they have to do it before the two-year period if they can figure out when that is, I don't think you should have an easy little form for renouncing, because I don't think it should be that easy to renounce, easy to opt out without thinking about what you are doing. And I think you could still require fairness, just as with prenuptial arrangements we sometimes require fairness. That is, an unequal bargaining situation can still exist. You know, the basic problem with all of this is that romantic love equals temporary insanity. So that we find these people who don't take care of themselves. They trust in their partner, they trust in their relationship, they're not thinking about the future, and it seems to me that your basic position is somebody ought to think for them. So, and I think it's the same after 2 years together for the person who wants to stay together or for the person who's economically dependent. If the other person won't get married, they may just have to agree to an opt-out. Now, you could do an opt-out and say you'll allow people to make provisions, but if they're not fair at death or dissolution of marriage, the court will make the agreement into a fair agreement. And this isn't to say that that people can't have good reasons for deciding that they don't want the incidence of marriage. For example, some people might opt out after talking about it and thinking about it because they're both self-sufficient and they don't feel that they need to depend on each other that way. But even if they make a perfectly reasonable choice at 2 years, 10 years down the line, one of them may have become disabled. And you have the same situation that of total unfairness if the marriage or the relationship, the cohabitation relationship splits at that time. So I don't think that the equities have changed, and I think that most of the reasoning of the book would suggest that the earlier waiver shouldn't count. So I guess I'm suggesting that there should be a provision that if it isn't fair at death or dissolution, that the court will make it fair. And also, if we're talking about opting out of benefits, you wonder why they would opt out of the government benefits. That is, it's not in their interest to opt out of the government benefits unless the tax thing is included. So they really shouldn't be opting out of that. So in short, I think the central problem here arises because of the great variety of people in the cohabitation relationship. As Cynthia shows, many are poor and uneducated, but also there are very sophisticated people who are having these same problems. And some of the problem with trying to get a good solution for this area is having to deal with both of these groups together. To opt out, you would have to know the law. You also need to be able to bargain. And I did think that in the book you stress vulnerability a lot, but sometimes when it suits the interest of your argument, you argue that people can take care of themselves. For example, low-income moms and divorced women are wary of dependent men, so they don't have to. So they probably won't let them take advantage of them. And then you say about old folks, they can draw wills to protect their children. But this presupposes rationality and some familiarity with family law. And the problem is that some of these people can do these things and some of these people can't do these things. So I think the conclusion I come up with in the end is that you really can't have both free choice and protection, that you have to choose. And it was clear to me from your book, of course I could be wrong, but it was clear to me that you would choose protection. And so I think you have to readjust your opt-out possibilities, at least to be sure that, that like prenuptial agreement, when the time for dissolution or death comes, inheritance comes, that the agreement can be reviewed for fairness. It is a wonderful book, and I very much enjoyed reading it, and thank you very much. I learned a lot.
My great pleasure to be here today to listen to what others have to say about Cynthia's new book and to chime in with my own 2 cents. Among one of my biggest pleasures in reading Cynthia's book is realizing that it is not just family sociologists and demographers who think that the living arrangements engaged in by American adults and the children they parent is a topic worthy of study. And I concluded the book feeling quite hopeful that now that the field of law has turned its laser beam on the implications of demographic behavior, we family demographers would get a little more respect, right? Because what we're talking about here is our bread and butter. Selfish matters aside, I was quite happy to be asked to read and make a few comments on Cynthia's new book. Unmarried Couples, Law, and Public Policy demonstrate the rewards of interdisciplinary study. The author has taken what is mainly contemporary behavior, cohabitation, or the formation of a shared living arrangement that is not one legally sanctioned by the state, as is marriage, and she assesses how these less formal unions are treated by the courts as a matter of family law. That Professor Bowman arrived at this interesting topic as a result of her applied work in attempting to aid clients in long-term cohabiting unions that dissolved highlights the very real ways that scholarly research can be more than just the accumulation of journal articles read by a narrow discipline. Professor Bowman addresses what might be done to improve the well-being of cohabitors, particularly those who are disadvantaged by existing family law. She examines how long-term cohabitors, a growing group, as I'm going to examine in a minute, might come to access similar rights to those held by married couples, that married couples have, as well as be held accountable for the same responsibilities. And we haven't discussed enough here the responsibilities, so I hope that we can get to that a little bit in the question and answers. Professor Bowman's goal is no less than to alleviate the injustice that can result when family law diverges from how people's relationships really play out in contemporary society. So I know that other people have talked about the gist of the recommendations, but you haven't seen them, and I'm addicted to PowerPoint. I'm sorry. So I thought I would just list the rules. All right. So these are the rules that emerge from the book. Domestic partners who've been together 2 years or have a child should be treated as though they were married. All right. So this is the fish or cut bait argument that we've been addressing. Couples who want to contract out of these obligations should be easily able to do so, and a system for registration as domestic partners should be provided, accompanied by all the benefits and burdens of marriage. So I'm going to state at the outset that I am largely sympathetic with Professor Bowman's goals to reduce the social inequality that seems to be borne the most heavily by women and children, particularly those from the least advantaged backgrounds. But I do have some questions regarding whether your proposals will have the intended effect, and particularly my biggest qualm is with the 2-year limitation, because we're going to be talking about how despite this amazing amount of work that she has done, cohabitation is a moving target, and it's really changing rapidly. Because I'm a demographer rather than a lawyer, I must say that this is a very new endeavor to me. And the topics that were covered in this book are, of course, my bread and butter. They're things I read all the time. I had no idea that lawyers would engage in some of the challenges of demographic processes, such as figuring out when cohabitations start or what consists of a cohabitation. We'll get to that. But I have spent the last 15 years studying young adult relationships. I study union formation, which for our purposes here is not joining a labor union, but entering into marriage or cohabitation. And there's a lot of very rich quantitative data, which Cynthia has reviewed, that goes over some of these demographic changes. And they look at factors like who's a cohabiter, what are the factors that affect whether people enter into cohabiting unions as opposed to marriage, and which factors affect the transition from cohabitation to marriage, right? Or leaving the relationship altogether. There's also been a new body of largely qualitative research, some of which has been done by people here, that examines the processes of entering into cohabitation and what it means for the families involved, how children come to be involved in these relationships. And it is very important to know that cohabitation has really become normative for contemporary young adults. And by that I mean that the majority of young Americans who get married now do live together before they get married. It's well over 60% of recent marriages that have been preceded by a spell of cohabitation. So my reactions to Professor Bowman's recommendations with regard to cohabitation and family policy are really shaped by my experiences looking at data as well as talking with cohabitors, both individually and as couples, about their living arrangements, what they expect, what they thought would happen when they began living together, and what they think will happen down the road. What I would really like to convey to those of you who are not familiar with the demographic data is that for those of us who are entrenched in the study of living arrangements, we are totally familiar with how challenging it is to study cohabiting unions because they are a moving target. Cohabitation has changed very dramatically just in the last 10 years, as I'm going to show you in a second. And so it is difficult to study because most of the data sets that we use to examine who cohabitors are outdated. A lot of this information was gathered in the 70s and 1980s. Much of it stopped in the early 1990s. Right? So among the most recent data sources, which Cynthia has pulled on admirably to conduct her study, is from 1995 and 2002 from the National Survey of Family Growth that I've highlighted here. But all of these studies, whether you're talking about the National Survey of Family Growth or the National Longitudinal Study of Adolescent Health or the third wave of the National Survey of Family and Households, they end at 2002. We are all eagerly awaiting the census, and I hope everybody here has filled out their census form, but we're not going to get that information for quite a long time. So we're dealing with information that is, is very dated. Right? So how do we know what's going on? Well, Cynthia published her book just recently, and I am sure she's going to be disappointed to hear that in many ways the data is already somewhat outdated. So today's cohabitors are different from those even from 1995. Right? They're much more racially diverse, and by that I mean that whites have caught up with racial minorities and Latinos, in particular in terms of the likelihood of living together. And that might be why some of this discussion is changing. Right? Cohabitation has also spread across the social class spectrum. Living together has become more normative among the highly educated, those who have college degrees, though they are still far less likely to cohabit than their less educated counterparts. Right? So we might think that cohabitation was led and that college students were in the forefront, but living together without being married has long been viewed the poor man's marriage, as Cynthia has reviewed in her book, and it still is much more predominantly engaged in by those who have less education. And by that I mean anything from some college and below. So high school dropouts, those with a high school degree who don't look different from the high school dropouts, surprisingly, and those with some college. And the point that some of the previous discussants diminished in some sense is the extent to which cohabitation has become a setting for having children. Cohabiting parents are increasingly bearing children in these unions, and the outcomes that used to result when couples got pregnant have changed dramatically. So there has been a decline in the past 2 decades in shotgun marriages, or marriages that you get pregnant and you get married. And there's also been an increase in couples who are dating and discover they're pregnant and move in together, right? But that is something a bit different than a precipitated desire to have children and be in a long-term union. We talked a little bit about children. It is really important that we do more than just say, well, 40% of children will at some point, 40% of cohabitors have children. We also need to talk about the fact that a growing proportion of children are being born into cohabiting unions. So in the last year, there's been a widely disseminated news story that nearly 40% of recent births have been to unmarried women. But these women are not technically single, as half of them are cohabiting. So this is among one of the most serious changes. This 20% of recent births would fall into Professor Bowman's group of those who would be considered like marriages. So it's not an insubstantial proportion, 20% of children. There's also been an increase in the proportion of women who, and men, but we tend to focus more on women in our data, who are serial cohabitors. Right? Now, I don't know how many of you have seen movies like Serial Mom, or you think about serial monogamy. Serial cohabitation means the same thing. It means that people have lived with more than one partner. Some recent, not yet published research suggests that many of these serial cohabitors are with these partners for over 10 years, but they will have accumulated 2 or more partners by the time they hit their mid-40s. Okay. And the point that I think is most challenging for Cynthia's book is that cohabiting unions are lasting longer. Right? So we tend to think of them as short-lived unions. The popular media suggests that they are largely precursors to marriage. That is changing as well. So if we think about the length of cohabitation and what period we should be considering if we're going to consider long-term relationships marriage-like, then perhaps it might be more than a 2-year period. Otherwise, we will be including a vast proportion of cohabiting couples. So if we look at data from the early 1990s, from 1990 to 94, based on the 95 National Survey of Family Growth, life table estimates indicated that that less than a third of cohabitors would live together for more than 2 years. Right? But this is a sizable proportion. If we just back that up, extend that across the decade to the 1997 through 2001, life table estimates indicate that 44% of cohabitors would live together for more than 2 years. Right? And I am not sure we need to think more clearly about whether the policies that you're recommending should encapsulate such a large proportion of the population. I'm not in disagreement, but that would really move us more toward a European system than what we have now in the United States. So this does represent a very large increase in the duration of cohabitation just over the 1990s. Right? There are a couple of reasons why cohabiting unions might be lasting longer, and Cynthia does cover some of these in her book. They get more to what role cohabitation serves and what cohabitors are thinking of when they are living together. One of the reasons for extended cohabitation is the rising level of aspirations that people believe need to be in place prior to marriage. Many people think that they need to have considerable amount of money saved up. They want to save for a large wedding. And I don't know who's heard the latest estimates that the average cost of a wedding is something like $28,000, which is out of reach for most disadvantaged couples. And many people also think that they need to have saved up and purchased a house prior to getting married. So clearly, to accumulate that kind of wealth often takes more than 2 years to accumulate, right? However, these couples, should they marry, wouldn't be really affected by the proposals set out in the book. But for many couples, particularly the least advantaged, living together has largely replaced dating. Right? So we can talk about the death of dating, and in many instances, when you interview cohabitors about how they began living together, they talk about how rapidly it occurs. So in some of my qualitative studies of cohabiting individuals and couples, they talk about moving in together within the first 6 months of dating, many within the first 3 months. So these individuals would be the most seriously affected by such proposals, in that the living arrangements that they make when they're young will have unconsidered long-term consequences. And I do want to emphasize that these individuals are far less advantaged. They're not college students for the most part. They're those who have some high school, or they have a high school degree or have some college. But what is driving their decisions to move in together so rapidly is not just desires for romantic relationships, but the expense of housing and the absence, in many instances, of a family safety net, or living with parents is just not considered a desirable place, and they would much prefer to live with a significant other than with roommates. For this reason, I think that we want to reconsider this 2-year duration that the book proposes. This figure is largely based on what is occurring in other Western countries, but the United States is exceptional in many ways, and this pro-marriage culture that we have here is in many ways one of them. We are among the only country that actually has marriage promotion policies. That's not a reason to not pursue this kind of process, but cohabitation means something very different here. So I'm suggesting that perhaps while a 2-year period might have worked just a decade ago, cohabiting unions have lengthened, and perhaps a 4-year period might be more appropriate, because if we look at the demographic data from the late 1990s, early 2000s, that would capture about 22% of cohabitors who would live together for 2 years or more. That is not including those who have children, right? But so I think it's important to consider what is the desired size of the population that your policy would address, unless you're trying to overturn the whole system of intimate unions, which, you know, wouldn't be bad, right? Okay, oops. So one thing is to think about the length of time, right? Now, other points to think about have already been addressed by the lawyers who've gone demographic on me. And among those of us who study this topic, a major question is that how do we know when couples have been living together for over 2 years? In most of these large-scale data sets that ask about it, there's a question that asks, at what month did you begin cohabiting? But these are often done at the individual level. And in my couple-level interviews, I find that couples don't necessarily agree about when they started living together, right? They don't agree about a lot of things. They don't agree about when they first had sex for various reasons, their social desirability pressures. They don't agree. But for cohabitors, there is not necessarily an anniversary, like a wedding date. And so actually getting at a date makes that challenging. Partners are also not necessarily in agreement about when they began living together. And in part, this has to do with the fuzzy nature of cohabitation. What is cohabitation? Now, Cynthia has addressed the fact that in many of these surveys it is defined differently. It could be 4 nights a week. It could be viewed as you stay together most nights without a definition. Can they have separate apartments? In my family class today, one of my students said, well, they're not paying rent, so that's not considered cohabitation. And so there are all of these very different definitions. For my qualitative interviews with cohabitors, yeah, that was you. For my qualitative interviews with cohabitors, I require them to have a shared place and no escape hatch, just because I want to know how they negotiate bills and stuff. But these surveys have very different definitions, and they could be misunderstood. So there's not even a hard and fast definition of what cohabitation is. All right? Now, this might seem, again, very picky or trivial, right? But I think it does have serious ramifications because there are such significant differences by social class. And one of your goals is to alleviate the inequity that is imposed on less advantaged women. So as I suggested before, both the qualitative and quantitative data show that the least advantaged enter into these cohabiting unions the most rapidly. So again, if we look for why, it has to do with finances. It's not, and marriage, as well as cohabitation, is often an economic arrangement. That is one of the underlying bases of challenging family law and thinking about how cohabitors might be better integrated. But it is something that we need to think about because it might very well have unintended consequences for the least advantaged. Right? So I'm raising this. I am not sure of the legality, the legal issues here, but I do wonder about the negative consequences of this 2-year time frame, and if there is any way to do a cost-benefit analysis of whether the benefits outweigh the costs. There might be drawbacks to not opting out of this 2-year marital contract that least advantaged are not aware of. So the issue of partners and their debt is something that is also understudied among those who study family formation. But we really might want to know to what extent, if couples are now considered marriage-like, they are responsible for each other's debts. And among the least advantaged populations, this is not a trivial issue. So the studies of single mothers, when they express concern about marrying their partners, are often unwilling to assume the bad behaviors that those partners have engaged in. And many of these single mothers sometimes think that these partners are more millstones than helpmates, right? In large part because debt is an issue. Okay. This is also, for me, I'm beginning to do some research with a colleague on this, and we know that over the last decade there's been an increase in personal debt resulting from an expansion of easy access to credit. So while we do not know necessarily the extent to which debt is affecting union formation, it is clear that it is going to be an issue for those who are not yet sure whether they are appropriate marriage partners, because they assess whether their partners are good or not at managing money. Okay. This is I think my last point. The most pressing point that I think that would need to be discussed at great length is whether relationship instability will really be reduced by imposing this 2-year time period, this fish or cut bait or opting out scenario, because the book suggests that it really will not result in greater levels of relationship instability, and relationship instability does have serious consequences for large numbers of children who live in these cohabiting unions. The evidence suggests that it is the least advantaged women who are most likely to be living to engage in serial cohabitation, and that these women often bring children into these relationships and then have new children with these new partners. And by imposing a 2-year limit, we might be encouraging greater relationship flux than currently exists, whether because they're leery of being in a more formal union with these men, or because the men don't desire to take up responsibility for this new family. So it isn't clear yet to me that this will reduce the instability and that it will not rather destabilize more of these relationships. There is also some evidence from the Fragile Families data collection that new parents often enter into cohabiting relationships following a conception because they're interested in doing what's best for the child. And they're not necessarily, they're not in the relationship for the long run, but they're trying to figure out how to be there during the early years of the child's upbringing so that they can provide instrumental help. So it, again, isn't clear how that will be affected. So those points aside, I think it's time to open up the dialogue. I encourage all of you to read this book, which, in my view, does an admirable sense of reviewing all of this very dense demographic data, as well as covering the rich array of materials on how cohabitation is viewed in other countries and how it has been viewed historically. And I am curious to hear what everybody else has to say. Thank you.
So we're going to give Cynthia a few minutes to respond. And then hopefully we'll have some time for question and answer. We'll finish promptly at 1:45.
Is there a way to turn this off now?
Yes.
Well, I'd like to actually start by thanking Cornell Law School for sponsoring a celebration like this, which certainly is a good reward for finally, I mean, it was reward enough to finally, after 5 years, have something to hold in your hand, right? But this is sort of overwhelming. And I'd like to thank Eduardo for organizing it, and Rachel Lukens for all the work that she did as well. And all of my colleagues here for the support that they've given me over the years that I was writing this book. It's been really remarkable. Now, I am so grateful for the insightful comments offered by each... What? You turned off the microphone?
I'll turn it back.
This is Judge Counsel. It's on. It's on. Okay. Yeah. I'm really grateful to the presenters for coming here and their insightful comments today. I know the effort it takes to get from Boston or New York City for a midday, midweek presentation, and I'm really grateful that both Martha and Sylvia made that effort for me. And thanks, Sharon, not only for your comments here, but for your help and your encouragement ever since I came to Cornell. I guess you were glad that somebody in the law school was finally going to start reading all the stuff that you were producing over there in the other departments. And I've noted down all your comments, and I certainly will ponder them. I'll just say a couple, maybe one thing about each right now. Sylvia, you almost wrote my next writing project for me, actually. I wanted you to know that when I was asked to give a paper in Tel Aviv next December, the one that I wrote up in an abstract was, in fact, about what should be the relationships between the children of a cohabiting couple and the non-biological parent, visitation, and all of that. So I'm on to that. And Martha, I think you're right that, and this is a difference that maybe Sylvia and I have in a variety of areas, that if I had to choose between choice and liberty, I choose protection of the vulnerable. That is true. I think that some of the problems that you point at are problems that exist, as you know, in the law of marriage as well. And I wasn't designing a system that would be better than that, actually, not because I wouldn't want to improve both of them, but in order to at least improve protections so that things like protection of persons who bargain from positions of inequality, that's something certainly shared by people signing prenuptial agreements as well, and I think that the same kinds of rules should apply to police them. It's interesting, especially Sharon, the focus on the two-year deadline, and he's now left, but a colleague of mine who was previously sitting in the room when a couple of years ago I presented a portion of this and suggested 2 years, I said, I'm not sure if 2 years is the right period of time or not. I think maybe 3. And he said, oh, no, don't change that. He said, that's because every time I've been involved in a relationship like this, it's exactly about 2 years when I start thinking, I wonder. So I'll keep thinking about that. Well, what I'd actually like to say was a few words about how I came to write this particular book in the form that it took. And that is the impulses out of which it arose. And they were personal, they were political, they were professional, and they were intellectual. The initial inspiration, though I didn't know it at the time, was, as I think you referred to, a client who came into me in the Northwestern University Legal Clinic. And she'd lived with a man for 15 years, and they had 2 children. And she was a victim of domestic violence. And she wanted to know what her rights would be if she left him. And she told me, everyone thinks we're married. We've told everybody we're married. We present to the world that way, but in fact, we never got married. And so I, of course, assigned a student to go out and do the research, right? And the upshot of that research was that, at least in the state of Illinois, she was entitled to almost nothing if she left. That is, she could take her clothes and her personal belongings, but she was definitely not entitled to any of the property they'd accumulated over the 15 years that they'd been together. She was not entitled to support. And that was because of a particularly punitive case law in the state of Illinois, which had the Supreme Court in its wisdom said, well, you know, we abolished the institution of common law marriage in 1905, and if we gave any remedies to cohabitants, we'd be bringing back common law marriage. So I began to think, well, maybe that's a good idea. We should bring back common law marriage. So I wrote an article that was called A Feminist Proposal to Bring Back Common Law Marriage. And because it would have protected a client in the position of this woman. But in the years that followed, even more states abolished the institution of common law marriage. Until now, only 10 states and the District of Columbia recognize it. And the doctrine had become anachronistic anyway, because with the immense rise in cohabitation, unmarried couples don't, in the words of the doctrine, hold themselves out as husband and wife. They openly acknowledge that they're living together and that they're not married. So it really wouldn't work. It wouldn't fit the situation now. So then I got an invitation to write an article for a symposium issue of a law journal that was focusing on cohabitation in an international and in an interdisciplinary context. And I was to write the portion about how cohabitation is treated in the United States. And others, it included work about how it's treated in Europe and Canada, but also writings by social scientists who wrote of the research that was being done on the institution, such as Sharon does. And the result of my research on that was to discover that although Illinois was the worst, that the position of cohabitants and the remedies they could expect upon the dissolution of their relationships was very restrictive in every state of the United States. And at the same time, other industrialized nations were increasingly recognizing cohabitation as a new family form and extending rights to cohabitants, both vis-a-vis one another and from third parties and the state. So I realized I needed to stop writing about common law marriage and the past and start writing about cohabitation and the future if I wanted to protect women in the position of that client. Now, I also had a personal motivation for undertaking this research because I was myself, at that time, a long-term cohabitant. And wrestling with issues about what our obligations should be to one another. So I was doing a lot of thinking about what one adult owes to another adult if they're in a committed marriage-like relationship but not in fact married. Now, Ben and I, unlike most cohabitants, were well-educated, informed, and not especially low in income. And so we were able to draft legal documents to deal with the obvious contingencies like hospital visitation, end-of-life decision-making, inheritance, etc. But we were never able to address third-party rights like health insurance that in the United States so often turn on marital status. Access turns on marital status. And I had a third motivation as well. Before becoming a lawyer, I was a political scientist, and so I've had a kind of drive in my research to include my background as a social scientist and to bring it to bear upon my research as a legal scholar. And cohabitation is an issue that has provoked an enormous amount of research by sociologists and demographers in the last 2 decades. But legal scholars had, by and large, either ignored that research or what I think is worse. They had picked up some portions of it, things that reflected negatively on the institution of cohabitation, and then drawn what I considered to be the wrong conclusions from the perspective of social justice. So I wanted to demolish the arguments of those legal scholars, okay? That was, I don't know, the intellectual or professional part of it. So in other words, my educational background and my personal situation and my experiences as a lawyer engaged in legal assistance practice all conspired to produce this book. I hope it will have some impact on the law in the United States, but I have no illusions in this respect. In Canada, England, Australia, New Zealand, most European countries, cohabitation has provoked substantial study by official government commissions and much legal reform. But in the United States, it has yet to appear on the political agenda. And so, as I say, I'm not sanguine about that happening really soon, though I never will give up hope. Now, I think I should stop and leave time for questions, or we won't have any at all.
We have about 15 minutes. I'll try to do this without microphone, but if we can't hear each other, then I'll pass this around. Are there any questions for Cynthia or any of the panelists? Yes.
So, I guess for Cynthia, I'm intrigued by this of the shadow that marriage casts over all these other relationships. I'll tell a quick anecdote about that. Then after, I'll find it. I have I guess it's called my very good friend from law school, who 15, 20 years ago was cohabiting with her long-time relationship. And she basically gave the whole thing. Let's get married or let's break up. And so he said, no, let's, this is this. And so she said, okay, so let's break up. But then he didn't move out of her apartment. And this went on for like 6 months, during which he started dating other people. So eventually he moved out and moved to another state. And so I saw this friend got married to somebody else who acted like but so I asked her just the other day in the car, whatever happened to ex-boyfriend? She said, oh, it's interesting. I just got an announcement from him saying that he and someone had bought a house together. It was sort of like an marriage. But it said, and this is what I heard it said, like the bride, but she's keeping her apartment also. So what do you do with that?
This actually, is a situation that the Europeans, well, I guess we use the same term, do we? I got asked to speak in London a couple of weeks ago, and they said, of course, you'll address LATS, won't you, L-A-T-S? And I said, what? LATS? Tell me what it is. It's this phenomenon of living apart together, which is apparently in Europe even much more widespread than here, for a whole variety of reasons. People have aged parents or children, and they want to maintain two households, or many of them have been married and they feel it'll wreck this relationship. They just don't want to risk the relationship. This is not something that I actually think, I've only started sort of thinking about it, should have imposed upon it marriage-like remedies. And my reason for thinking, or that I would not presume it should, and the reason for thinking that is that if you've got two households and you're maintaining two households, first of all, you probably are not in economically desperate straits. And second, The thing that if I had to choose one of the factors that was most important to me about why you want to protect these couples, I would point to economic interdependence. And so until I'd seen studies of people who were lats and saw how they handled their money, and I don't know whether those studies have started at all. I wasn't able to find any in my brief period of research before going off to talk about something I just heard of the day before. But since I heard about it, I see it all around me. And I thought, oh, that's my sister-in-law. Oh, that's, this person. A student comes in and talks. And so it's quite a common phenomenon. But I don't presume that should immediately mimic marriage in its remedies. Yeah, you're not the first person who's suggested it, in fact, and numbers of groups and certain courts who have taken a particular issue and decided that in their state cohabitants would be treated like married couples. For example, New Jersey under negligent infliction of emotional distress. Say, here's how you determine cohabitation, and then they give the court 5, 6, 7 factors, right? And the reason that I reject that is, first of all, it involves the court in a very, the questions tend to be rather intrusive, and they take up a lot of court time, and they kind of often, how they're formed, impose a certain manner of life on the couple. And so I opted for a bright line rule because a period of time after which you could presume interdependence of the couple. Now, that's a stand-in. Should I just say interdependence of the couple? I mean, you have to really put on a lot of evidence, and ever since the rise of no-fault divorce, I mean, family law courts don't like having to take lots of evidence about the relationship of two people, and they'd be having to do that again. So that's why I rejected it, but I understand why you bring it up. Yeah, I think I would apply the same rules, basically. I didn't write that same book because, in part, I wanted to write a book about this topic, and I didn't want to take on all of that at once, and for really pragmatic reasons. But I wouldn't have differentiated the rules applied. You mean, are same-sex couples as likely to be economically interdependent? I think slightly less so, but if they have children, they are. Do you know some of the studies on that?
Among heterosexual cohabitors, those who have children are most likely to be interdependent. The evidence on those who don't have children is that they are often not financially intertwined. But as for financial arrangements among same-sex couples, I do not believe the data are out there that would allow us to estimate that. The number of same-sex couples in nationally representative data sets is very small, and very few of these data sets actually collect enough good information on, especially if they don't collect it longitudinally, about how financial arrangements change. So we don't know things like the level of debt, or we might know whether they have a joint account, but we don't know who controls it. And so we would expect that to increase with the duration of the relationships, but we don't know.
Well, I didn't mean that the police would be sent in and they would be separated, obviously. They could go on cohabiting, but if they did, then these a marriage-like obligation would be imposed upon them. Mm-hmm. Yeah. Yeah, yeah. It's really interesting to look at the array of arrangements that other countries have come up with. I think the one that's kind of the most similar in the sense of providing a model for the United States is Canada, because it's a federal system and similar legal system, et cetera. And ironically, what they've done is actually bring back a form of common law marriage that imposes common law status in relation to support obligations between persons who cohabit and or have a child. Other countries, the country with probably the longest experience of cohabitation is Sweden. And it's interesting because it's been common for so long that people sort of don't regard cohabitation and marriage as different. And because they don't, there aren't that many protections that need to be extended. Now, the other piece of that, of course, is that Sweden and the United States are at different spectrums on the welfare state as well, right? So that in Sweden, an individual at the end of a relationship is not going to be left destitute because the state, in fact, has lots of protections that run to them as an individual. And whether a country has those protections or not is really interesting to consider in thinking about what you would do. And it's a kind of conundrum for me, because one way of looking at what I've suggested is to say, oh, I see, you just want to privatize all these welfare functions, right? And assign them to the former partner of the person. And of course, that's not my inclination. I'd rather that we socialize those functions and people didn't have to depend on a former partner for their health insurance or their support. But that's not the world in which we live here in the United States, and so we live in this second best kind of situation. In the UK, they're not that much ahead of us, but in most other countries, statute law has been changed so as to interpret spouse so as to include a cohabitant. So that, for example, in terms of pensions or in terms of variety of protections available at the federal level in Canada, they're extended to cohabitants already. So that a lot of the remedies that we can't get from the state already are given to people either as individuals or as spouse-like people. So there's a whole variety of, Australia has what are called de facto relationships or de facto partners, and most countries have taken on in kind of an incremental fashion by issue and by group. It's rare that you get the kind of social engineering that I'm suggesting, certainly. And of course, we could never do it here, right? Because family law is a state law matter, and we have 50 states, and it's determined in every one of them, and it could be different. Did I answer your question, Aziz? Yeah, sure. The City Hall, yeah. Do you know, that's something I've been thinking about for a long time, and I'm not sure I can give you a definitive answer. And in that article I wrote in the symposium, the European authors were all pushing this on me, that the reason that it's different in the United States is that the United States is such a religious country. And I was resisting that, saying, well, first of all, I'm not entirely sure it is such a religious country, and I'm not sure that that's the impulse out of which this comes. There is a moral kind of condemnation, but the assumptions are faulty, right? That just as with same-sex marriage, they assume that cohabitation is going to, if it spreads, it will destroy marriage, and marriage won't continue as an institution. Well, you can very much continue to have marriage as an institution, even if it's not a state institution. A lot of people in Europe do still have a second marriage in a church. I'd be interested actually in hearing your opinions on that too, as to what you think about the role of religion is, because I'm still thinking that through.
Actually, from a sociologist's perspective, Andy Cherlin published a book last year called The Marriage Go-Round, where he argues that it is because the United States is so much more religious than these other countries that we have things like marriage promotion as opposed to and it means that we value relationships, but we also elevate marriage and make it sacrosanct, and that's why we have high divorce rates, but then people dive back into marriage, right? So he's arguing that we are different because we are a more religious society, and that shapes, we have much more in the way of morality policies. Yeah.
Cut this off, but we are out of time. So please join me in thanking our